The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to our ongoing, now post-trial coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I am Attorney Andrew Branca for Law of Self-Defense. So I wrote up this blog post yesterday, just as the verdict was being announced. As I'm sure you all know, the verdict was guilty on all counts. But given that Prosecutor Blackwell's contemptible closing rebuttal will certainly be grounds for reversal of these convictions, and the issues discussed in this content are an important facet of that rebuttal, there's good reason to go ahead and make this content available regardless of the verdicts in the case. Incidentally, if you're enjoying this content on the day of publication, and I'm producing the video and audio versions of this on April 21st, 2021, you might be interested in the Derek Chauvin post-trial analysis webinar I'll be doing live with Professor William Jacobson over at Legal Insurrection tonight, April 21st, 2021 at 8 p.m. Eastern Time. The professor and I will each provide our own perspectives on the trial and the political dynamics surrounding the trial that drove these verdicts, as well as have live Q&A. If the timing doesn't work, 8 p.m. tonight, April 21st, or the event's already passed when you learn of it, you can also catch a recording of the webinar after the fact. Now, either option, participating live or watching the recording after, does require a registration, which is free, but you do have to sign up. You can do that by pointing your browser to lawofselfdefense.com/webinar. Okay, with that out of the way, let's jump into the big lie of the 3-minute plus restraint while pulseless, the lie promulgated by Prosecutor Blackwell in his rebuttal closing of the trial of Derek Chauvin. Now, politically energized prosecutions often lack factual or legal merit, and thus to satisfy the mob and advance the baseless prosecution, it's necessary to build the case upon a foundation of lies. We've certainly seen that in many of these high-profile cases, including the George Zimmerman trial. There, the lie, one of many, was that he got out of his car after being told by police not to do so. That never happened. The Michael Brown case, there the lie, of course, was hands up, don't shoot. The more recent Jacob Blake case, there the lie was that Jacob Blake was unarmed. You can clearly see a knife in his hand in photos of the scene. Unfortunately, once the public has been drowned in these propagandistic lies for months or years, it becomes the public's lived truth. And almost nothing can expose that lie for what it is. It's simply believed as truth forever and on a societal-wide scale. And now we're seeing the same development in the Floyd case. It's become common to see claims on the internet that Derek Chauvin continued to restrain Floyd as long as 3 or even 4 minutes after he knew Floyd no longer had a pulse. And it's not just the internet, it's the actual prosecutors too. This is what Prosecutor Blackwell said in his closing rebuttal yesterday. Quote, "Why is it necessary to continue applying deadly restraint to a man who's defenseless, who is handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and go on and do that for another 3+ minutes before the ambulance shows up? And then they continue doing it. How is that a reasonable exercise in the use of force?" This laundry list of events that Blackwell runs through, the handcuffing of Floyd, Floyd's cessation of breathing, Officer King's inability to find a pulse, these are all events that took place at different times, obviously. Floyd was handcuffed a considerable period of time before, for example, the officers had reason to believe he was not breathing or couldn't find a pulse. So not all of these things are for a duration of the claimed 3 minutes. But fortunately, we can know the exact times that various events happened from the various video footage, particularly the body-worn camera footage of the various officers whose body-worn camera timestamps are all synchronized. And particularly helpful for the purpose of this discussion is the body-worn camera of Officer King, which in the video of it, you can see it ends in serial number 5AT. From the period just preceding the first and only check for pulse by the officers until the arrival of the paramedics. And I'll be referring to that video clip throughout this post. If you're listening to this as a podcast, obviously you won't be able to see the video, and there's no point just playing the audio portion of the video clip. What you need to see is visual in nature. So I'll have to refer you to the blog post over at lawofselfdefense.com/blog. But we do embed the video in the text version of today's content. I also include, by the way, a written transcript chronology of dialogue during that segment of the video we'll be sharing with you with various timestamps so you can visually see in written form when things happened in terms of their chronology. And that's as a downloadable PDF if you'd like to do that. Now, I'll ask you to accept, for the time being, accept my word that this brief video segment includes all relevant mentions by the officers of Floyd's breathing and pulse, but in the event you want to verify that claim, in case you don't believe me, I've also embedded the entirety of King's and Lane's body camera footage of this event from start to end at the bottom of the text version of today's content, so you can watch the entire body camera footage if you don't believe that this is the only reference to a pulse that happens throughout the entire event. Now, we know that the paramedics are on scene at Floyd's side at 20:27:41. That's 8:27 and 41 seconds. From now on, I'm only going to say the minutes and seconds, folks, because the hour is the same throughout. But we know the paramedics arrive at 27:41 as evidenced in screen capture from Officer Lane's body camera. We can see the paramedic standing beside Chauvin, and we can see the timestamp of 20:27:41 in the upper right-hand corner of that image. And I do have that image embedded in the text version of today's content. So if we accept that the critical events here in the sequence cited by Blackwell in his quote are not the handcuffing, but the issues of breathing and pulse, the question is, what do we know about those events from Officer King's body camera? Well, we know that Floyd was still visibly moving at 24 minutes and 43 seconds, so there's no need to check for a pulse prior to that point. We also know that the officers believed that Floyd was still breathing at least to timestamp 25:13, because at that point, one of the officers, it's unclear which, comments he's breathing. That's about 2.5 minutes before the paramedics arrive, and Floyd hasn't stopped breathing yet. So, in other words, Blackwell's apparent claim that the officers kept Floyd restrained for 3+ minutes after he stopped breathing is demonstrably untrue. He's still breathing within 2.5 minutes of the paramedics' arrival. Worse, however, is the claim of the 3+ minutes of restraint in the context of a purported absence of pulse. The first time any of the officers are unable to find a pulse on Floyd, the only time they're unable to, is at 26 minutes even. That's a mere 1 minute and 41 seconds before the arrival of the paramedics, a far cry from 3+ minutes. Once again, Blackwell's apparent claim that the officers kept Floyd restrained for 3+ minutes after he had no pulse is also demonstrably untrue. These are false claims of fact made to the face of the jury after the defense has no possible means of correcting the falsehood and moments before the jury goes into deliberation on one of the most important issues in this weeks-long trial. Now, maybe that's not grounds for a mistrial if the falsehoods are corrected prior to the jury going into deliberation, but they were not corrected. Grounds for reversal of a conviction? I absolutely think so. But that's not even the most important facet of this issue of restraint and pulse in this case, at least not in the context of whether Chauvin is guilty of a crime. More important to the question of guilt is what Chauvin actually knew, because that's all that could have informed the decision-making of a reasonable officer. And all the King body-worn camera video tells us about there being no apparent pulse at 26 minutes is that Officer King could not find a pulse. It does not inform us that Officer Chauvin was aware that King could not find a pulse. That is, the only evidence on the issue of inability to find a pulse is relevant solely to Officer King. We can hear him saying, "I can't find one," after checking for a pulse at 26 minutes, as I've already noted. What we don't know, however, is whether Chauvin actually heard this statement. At no point does Chauvin acknowledge King's statement of inability to find a pulse. We can hear King's statement on his body camera, so why wouldn't Chauvin have heard him? Well, one reason could be that King's body-worn camera microphone is only inches from King's face, crouched over Floyd as he was, much closer than King's face was to Chauvin's ear. And in addition, there was a great deal of other audio sources demanding Chauvin's attention. Indeed, at the identical time that King states, "I can't find one," referring to a pulse, the police radio is chattering loudly, and Chauvin surely would have been listening for radio reports of EMS progress to the scene. In addition, concurrent with this broken exchange between Chauvin and King regarding Pulse, there was another dispatch call involving a suspect pointing a gun at a crying child. It's difficult to think of a call that would be more distracting to the attention of a police officer. Further, Chauvin was positioned around the rear fender of Squad 320 and far more exposed to the angry shouts from the crowd than was King. And the crowd at this precise moment was exceptionally loud. It seems quite possible that between King speaking, the radio chattering, and the crowd shouting, that Chauvin simply never heard King say, "I can't find one." Indeed, immediately after King makes that statement, amid radio chatter and crowd noise, Chauvin responds, "Huh?" This suggests that he heard King say something, but he didn't hear exactly what was said. King then responds to Chauvin's "huh" with, "I was checking for a pulse." Note what King does not say here after Chauvin indicates a need for clarification. He doesn't say, "I was checking for a pulse and I couldn't find one." King may have presumed that Chauvin heard his first earlier statement that he was looking for a pulse, and therefore, "I can't find one," completes the message. That's the entirety of what needed to be communicated. But from Chauvin's perspective, which is what controls for purposes of his criminal liability, if all he heard in an understandable manner was the second statement, "I was checking for a pulse," in the absence of having understood King's prior statement that he hadn't found one, Chauvin might have reasonably inferred that King had found a pulse. After all, not finding a pulse is important information that wouldn't be left unsaid. And as far as Chauvin knew, it had not been said because he hadn't understood it when it had been said. And that was the one and only discussion of pulse between the officers. The bottom line here is it's quite possible that Chauvin never knew prior to the arrival of the paramedics that Floyd was without a pulse, and thus that there was in fact zero time, not 3+ minutes, not 2 minutes, not 1 minute, not 1 second, during which he was knowingly restraining a Floyd that he thought was pulseless, in which case continuing to restrain Floyd for the arrival of expert medical care would simply have been prudent in custody, in care, police practice, and not criminal conduct or denial of emergency care at all. On this last point, I'm obliged to note that it would have been helpful for defense counsel Nelson to have made this argument to the jury during his own closing, using precisely the video clip that I've embedded in the text version of today's content. And as I've already mentioned, if you don't trust the video segment I've pulled out, I have included the full-length video, the entirety, half an hour or so, of the King body-worn camera footage entering in serial number 5AT, as well as the Lane body-worn camera footage ending in serial number 5Z7 in the text version of today's content. Okay, folks, that's all I have for all of you now. Obviously, we all know by this point that the verdict has come in, guilty on all counts, so the next step will be sentencing, and of course, after that, the appeals process, the inevitable appeals process, given all the grounds there are for appeals in this case. Before I go, in view of the ongoing riots periodically raging across the nation, I've also taken the liberty of putting together a special opportunity to access our best-selling course, Lawful Defense Against Rioters, Looters, and Arsonists. This is a video course, both online, streamed, and DVD formats. You can choose your preference or get both. You can learn more about that course by pointing your browser to lawofselfdefense.com/riot. And thanks, as always, to both Legal Insurrection and CCWSA for the support that makes my coverage of this case possible. All right, folks, until next time, I remain Attorney Andrew Branca for Law of Self-Defense.